10 минут, пожалуйста.
Thank you, Mrs. Chairperson, ladies and gentlemen, dear friends. DCAF is an international foundation established on the initiative of the Swiss government to promote democratic security sector governance through security sector reform. Our mission is to support effective, efficient security sectors which are accountable to the state and its citizens. It's an honor and a privilege for me to present to you one aspect of our work which may be particularly interesting to you, even groundbreaking, namely the development of public-private partnerships in the area of private security regulation. Today's simplistic assumptions about who actually delivers security are constantly challenged. The reality, both in the North and in the Global South, is not that of a Weberian state with a state monopoly on the use of force. It's more often that of a hybrid, often fragmented system composed of a diverse array of public and private actors whose roles and responsibilities are blurred. DCAF has been chosen as Switzerland's strategic partner in developing an innovative approach to private security regulation. I believe that much can be learned from this example for also other multi-stakeholder approaches, and I would like to present to you the two documents concerned, the Montreux document and the International Code of Conduct. Why has Switzerland engaged in the first instance in this area? It will come to you as no surprise that the abuses linked to private security companies in Iraq played a powerful role in that. First, the phenomenon exploded even simply in quantitative terms. During the first Gulf War, the ratio of uniformed military to contractors was 55-1. The ratio for the Iraq War was 1-1. Moreover, the size of the industry was reflected in an increasingly diverse set of activities, expanding from logistical support to protection of military personnel and assets, training and advising of armed forces, the maintenance of weapon systems, or the interrogation of detainees. Concerns with the international community were raised on multiple levels. First, there was a sense of impunity, that the industry seemed to exist in a legal void. There was also an unease that a large and continuing growing industry was operating under the radar screen. Beginning in 2006, the Swiss government, together with an international committee of the Red Cross and DCAF, started to launch an intergovernmental initiative to clarify legal issues surrounding the use of private military and security companies in conflict situations. There were two guiding principles: depoliticize the issue as far as possible. It was made very clear that the process ought neither to legitimize nor condemn the industry. Secondly, don't try to create new obligations for states. Rather, the goal was to clarify the ways international humanitarian and human rights law apply to the operations of private military and security companies. The process also sought to identify concrete good practices that states could implement. 2.5 years process led to an agreement on 17 September 2008 in the so-called Montreux document. It consists of 27 core international obligations and 73 good practices designed to assist states in complying with these obligations. Core obligations include ensuring respect for international humanitarian law, protecting human rights, ensuring criminal accountability, and underlying state responsibility for violations committed by PMSC. The good practices are intended to enable states to determine which services should be contracted out, to establish a domestic authorization system, and to ensure effective national oversight, including parliamentary oversight. The Montreux document can be effectively considered as a blueprint for regulating the private sector industry. In other words, states agreed to engage private military companies only if they observed certain rules, and set out what these rules of the game should be. It turned, however, also out that there needed to be a document not only for states, but then also one for industry. This became the International Code of Conflict, International Code of Conduct, an idea launched in 2008 by Switzerland. Over the course of an 18-month process period, a multi-stakeholder process that included states, Switzerland, Australia, the United Kingdom, the United States, civil society organizations, including Amnesty International, Human Rights Watch, and Human Rights First, and the leading elements of the industry worked hand in glove. They elaborated a text that the industry could live with and states could see their interest respected, and human rights organizations, civil society organizations found decent. In this text, the Code of Conduct, the industry commits itself to respect, in simple terms, the obligations set out as a standard in the Montreux document. These two documents became rather a success. The code, the Montreux document, started out with 17 states endorsing it. Today, 50 states, as well as 3 international organizations, namely the OSCE, NATO, and the European Union, have endorsed the document. The Code of Conduct was initially signed by 58 private security companies. Today, there are 708 who are members. 139 of these have gone even a step further and joined a third undertaking, the Association for the Code of Conduct. In order to provide teeth to the oversight of the code, this association was created in Geneva in 2013. It is a multi-stakeholder governance structure that makes it up, again composed of governments, companies, and civil society. With the support of the dedicated secretariat supported by DCAF, the association will be responsible for certifying member companies. In other words, check whether they not only claim to respect the Geneva Conventions but actually do, fulfill a monitoring role, and addressing complaints by third parties. The COCA has already, as the association is called, has already gained significant support from companies. The appeal is growing. What has been achieved in the case of private military and security companies was to regulate, in an exemplary form of soft international law, problems that could not be solved with hard international law. It would have been difficult to negotiate a treaty on mercenaries. The United Nations tries it for almost decades. So to reconfirm existing law applying to the situation of private military and security companies provided an innovative approach to find an international norm, define a standard that made sense and could be accepted by everybody. These soft international law approaches, multi-stakeholder approaches that unite states, industry, private industry, and civil society organizations, I believe will mark the future. So let me cite just one example where this is an interesting approach, namely cyber and the future of the internet. There is hardly any chance to get an international agreement of the classical type. However, there is no need to say how urgent and multifaceted the job is. Switzerland will therefore, from the 17th to 19th of November, convene here in Geneva an international conference on the future of the Internet, where we shall try to see whether and how a common ground can be found to define the rules of the game for the Internet. The multi-stakeholder approach that has been the key to success in the case of private military and security companies lends itself, we believe, as a possible avenue also to such highly important issues as the Internet. But the list can be prolonged, but I don't want to prolong my intervention. Thank you very much for your attention.